You can hear my voice, sir? Good evening.
Yeah, but I can't see you.
You can't see me. Okay. I'll start video.
Yeah.
Now?
Yes.
Okay. Okay. So,
So today you will finish in 2 hours.
before that, actually, today I'm much more comfortable in terms of content wise because it's not so vast content. So I'll be only dealing with today death insolvency, compromise, and withdrawal of suit, appeal, reference, review, revision to Supreme Court. And then I'll just leave a statement that as far as other things are concerned, where no remedy is provided anywhere else, suppose you're remediless, your right under 226 is alive or 227, that I'll not be able to deal much because I think by the time
So that so somebody else is doing.
that's right. So I'll just leave it that link
You
there
don't
and somebody else can take it from there.
Yeah, next Vyom Shah is dealing with 226,
Oh, lovely.
227.
Super, super. Very good.
So that is
I'll
not
just
a
provide a hyperlink to those, that particular
yeah. He's going
they
to
can
do
take it
that,
further.
and he's going to do also the specific relief act and
Okay, okay.
those.
Achha, now, sir, regarding the compilation of judgment that I had prepared, sets of judgments, I will sharing with you or with Mr. Jani, sir, and Jani, sir, can then circulate in the group. How do I go?
Better let Jani do it on the group. Is it
So I will,
PDF file? You can WhatsApp it to him.
yeah, I'll WhatsApp to him and maybe he can share in the group so that we take care of it. So, I mean, those judgment will also take care of those citations, which I'll be including in the present discussion today.
Yes. Not to worry. Or if you want share screen, I can share that.
But will they be in a position to download it? That's not a possibility unless I do it on upload it on a Google Drive. So it will be of no use.
It's a big one. If it's
no, let it be. I'll share in the group only. That will be better. We can just take it there.
In the chat, no? You can put it in the chat also. If you share it in the chat, if you attach it to the chat, it will go to everyone.
Okay, yes, there's a yes, I can understand. It's there.
Yeah.
Your computer. Okay, it can be done. Very good. I saw that.
So then they'll get it straight. Whoever is attending.
I'll just still.
Good afternoon, everyone. Welcome back. We have Mr. Rajmani Verma, who will complete his session today on the overview of CPC Part 2, dealing with his rest of the portion of the CPC. And as I have mentioned, on 24th, Wednesday, day after tomorrow, we have Mr. Vyom Shah coming to speak on the Commercial Courts Act, Constitution, Letters Patent, and the Specific Relief Act. And then we will have on 8th July a session on execution under Order 21 by Mr. Gaurang Mehta, who is an expert in execution. So that will complete almost all topics in CPC paper. So I'm handing over to Mr. Verma. Thank you.
Thank you, Nilesh Bhai. On the last occasion, I had the occasion to discuss on various provisions of special suit and also various orders that could be passed or the application could be made under certain provisions of the CPC as well as the sections as well as the orders, those interlocutory proceedings. And then I was about to start the provision with respect to the effect of death, marriage or insolvency the parties pending the litigation. And by the time the time was over. So I will start from where I ended on the last occasion. So before I begin, let me just make the participants understand about the fact that once the proceeding starts, let's say we have filed a suit, the appeal, that's a subsequent event, but till the final discussion on the points raised by the parties, that is the final hearing, takes some time. It may take 10 years, 15 years down the line. In between, lot of developments may take place. Suppose today one gentleman who has filed a suit and is at the age of 55 years. After maybe 5 years or 10 years down the line, he may fall sick or ultimately he may expire, pass away due to any ailments or old age. That could be one development which might take place. Second, the plaintiff or the defendant, whoever is the person, plaintiff or defendant, may enter into a marriage and therefore the name, this status changes. Or in the alternative, there's also a possibility that either the plaintiff or the defendant, because of certain circumstances, may be declared as insolvent. So these are the three different eventualities that takes place that is covered under Order 22 of the CPC. What are the, if such kind of event takes place, so what are the procedures that is laid down under the CPC? There was one more event that can also take place, where after filing of the suit, or between the date of filing of the suit and the final hearing of the case, a person also may turn out to be mentally incapacitated because of some kind of memory loss or any kind of disease, whereby his uh, ability to decide, ability to make any judgment or give any instructions also impaired. So that we have already discussed earlier, because that is covered under the special suit, where about the mental the element was also discussed on the last occasion. So that is covered separately, which already have been taken care of. Now, therefore, the only three eventualities that is we are talking about is death, marriage, and insolvency of the parties. That is given under Order 22 of the CPC. Now, as far as the death of a party is concerned, that is governed under Rule 3 to 6. Then Rules 10A, Section 305 of Indian Succession Act, because there's a reference, and also Section 37 of the Indian Contract Act. And there is also a relevance of Section 6 of CPC that also will have to take into consideration, which I will deal with it. As far as the effect of marriage is concerned, same Order 22, but Rule 7 deals with that. As regards the insolvency of party, Rule 8 deals with that. And there are certain miscellaneous provisions which invariably applies to the above three cases and how the effect of that takes place. And before I begin, in the case of such events where the change of status of the person takes place, either because of death or marriage or insolvency, the application will have to be made in the form of chamber summons. And now presently we have come with the new concept of interim application, where all notice of motion and the chamber summons are converted into interim application single file. And now coming to the provisions of death. So during the pendency of the suit, if there can be possibility that there are various plaintiffs, there are various defendants, there could be a sole defendant, or there could be sole plaintiff. So therefore, the Order 22 Rule 1 and Rule 2 and 3 and 7, they all take into consideration various eventualities as to whether one of several plaintiffs or one of the several defendant dies, or where one of the several plaintiff dies, or where one of the several defendant dies, where the sole defendant dies, and where the sole plaintiff dies. So therefore, what happens? So the cardinal rule is that once a plaintiff has filed a suit, or against the defendant when the plaint has been filed, the suit cannot abate if the right to sue survives, either to the plaintiff or to the defendant. So that is the most important aspect about it. If the right to survives either against the plaintiff, or in case the defendant dies, against the legal heirs of the defendants, in that case the suit will not abate. What is abatement of suit? Order 22 talks about abatement. That's the concept. Abatement means the suit will come to an end. The cause of action will come to an end. Therefore, if suppose the plaintiff who has filed a suit against the defendant in a case where for specific performance of doing a painting for him, and the defendant dies, certainly the cause of action accrues to the defendant, but later on it doesn't survive to the legal representative of defendants, and therefore the right to sue does not survive qua the defendant's legal heirs. Therefore, the suit comes to an end. Similarly, if there is only single plaintiff and he alone, for example, in a defamation suit, ultimately the person who's been defamed is the plaintiff. So therefore, the cause of action arises or accrues only to the plaintiff. And the moment he dies, his reputation also comes to an end, and therefore the suit cannot be proceeded further. So what happens? Those various eventualities are given here in order 22, rule 2, 3, 4 and 6 and 7. Now, I'll just deal with each of the instances now where one of the several plaintiff or defendant dies. So let's say there are various plaintiffs or various defendants, and the right to sue survives in favor of the surviving plaintiffs or the surviving defendants alone. That means, as far as the other parties are concerned, the rights to sue does not survive against them, either against the plaintiff or against the defendant. In that case, the suit will not abate and they will be deleted from the array of the parties, and the court shall record that fact and will proceed with the remaining parties who are alive and against whom the right to sue survives, and as regards the other defendants, the right to sue does not survive. So that is one event. Second event is that where either parties or any of the parties to the suit expires or passed off, then what is to be done? In that case, the rule 6 says such suit shall not abate whether the cause of action survives or not. So therefore, the general rule that if the cause of action or the right to sue survives, the suit should not abate. But in a case where if any of the parties to the suit dies after the conclusion of hearing, prior to the pronouncement of judgment, in that case the suit does not abate. The rule which is stated just now, I just spoke about it, they are not applicable, and the court is free to move ahead further, and the court will pass the order, and such order passed by the court in that case will have the same effect and force as if it has been pronounced before the judge or before the death of that person. Now, what is the time limit that is prescribed for bringing the legal aids on record? Limitation Act Article 120 provides for 90 days. So therefore, within 90 days, one has to approach the court, and there's a duty cast upon the whomsoever. So suppose the defendant is represented by a particular lawyer, his clients he comes to know that one of his client or some the parties to the suit has passed away. It is his duty of the counsel, upon knowing about the fact that someone has died who's a party to the suit, to him he is representing, to inform the plaintiff's advocate that, look, Mr. So-and-so, this particular person has died and these are the legal heirs, you are requested to take further steps. So it is a duty cast. So obviously when the plaintiff files a suit, he will not have any idea, because ultimately he will be the other side will be represented by the lawyers, and he will not have any idea who is coming, whether the defendants are alive, who is not there. So the defendant's advocate's duty is to inform about the demise of the person. And therefore, the rule 4 also says that suppose the plaintiff is not aware and he comes to know sometime later on, maybe 90 days, that is a limitation period that is expired. In that case, what is to be done? So therefore, from the date of knowledge, he can apply to the court that due to despite due diligence, I was unaware about the demise of any of the parties. Now this is how I've come into this has come to my knowledge, and therefore whatever days that is of delay, that needs to be condoned, and whoever is the parties to be required to be made as a parties to the suit in place of the person who has died be brought on record, and the court will take into consideration, and then matter will proceed further. Now, coming to the marriage of parties. Now, we all know, it's quite logical also, it's quite obvious that if the person who is a lady and she has filed a suit prior to her marriage, and after she gets married, her status does not change, and in that case only the name can change. She can make a simple application on the basis that she's got married, and in that case the suit will proceed further. Similarly, in the case of insolvency of parties, during the pendency of the suit, either the plaintiff or the defendant can be declared as insolvent under the relevant Presidential Insolvency Act or the Provincial Insolvency Act, now which has been amended because of the IBC code, which is yet to take into consideration. In that case, the court will either implead the official assignee, and suppose the official assignee in case of the plaintiff, the official assignee is, let me explain you, once the plaintiff or the defendant, any person who is adjudged to be an insolvent, in that case, there's an assignee or receiver gets appointed in his place, and he becomes the person in de facto or de jure to take up all the proceedings against or in favor of that person, whoever has been declared as insolvent. So in that case, the entire suit can be proceeded further. Assignee or the receiver will become step into the shoes of the plaintiff or the defendant, as the case may be, provided if the plaintiff gets, the rule 8 says, if the plaintiff gets becomes the insolvent and the assignee is appointed in his place, in that case, if the assignee does not proceed to further or give security for the cost, in that, because if the assignee becomes the steps in the shoes, he has to provide for security for the cost for performance of these duties to take care of the estate of the insolvent. In that case, if the assignee does not take any further steps to prosecute or proceed further in the matter, in that case, the suit can abate, and the defendant may make an application to the court for dismissal of the suit, and matter can proceed further. However, in case of defendant, if he becomes insolvent, then there's a separate standard of application is there. In that case, the suit, in case of defendant, if he becomes insolvent, in that case, the proceedings or suit which is pending against the defendant will be stayed. Now, what is the effect of abatement? Now, if the plaintiff or the defendant expires and the right to sue survives, but the legal heirs are not brought on record or the representatives are not brought on the record, in that case, the suit automatically abates. There need not be any order for the court to make that the suit has abated because the parties, no further legal heirs have been brought on record upon the demise of the plaintiff or the defendant, as the case may be. So once the second consequence is that once the suit abates, no fresh suit can be brought on the same cause of action. So therefore, the entire suit stands still and comes to an end. And obviously, if there is a delay, I just have told earlier that he can make an application for setting aside the order, and keeping in view the merits of the matter, the court will be very liberal to allow such kind of condone the delay and take the matter further. Now, there is a appeal. If there's a provision of appeal under this, suppose the suit is abated and the suit has not been allowed to be proceeded further and the order is passed. In that case, such order that is passed are also appealable, except, and also these provisions are also applicable to the execution proceedings, except rule 3, 4 and 8. And also, writ petitions and revisions, they are not suit proceedings within the meaning of the CPC, or because they are independent and extraordinary jurisdictions proceedings. Therefore, still the proceedings or the rules which generally apply to the suits in the case of abatement of the pleadings, in that case, the such proceedings are also applicable to the writ petitions and the revisions. Second criteria that we need to take into consideration, if a suit has been filed under Order 1, Rule 8, as regards the representative suit, in that case, one of the parties out of numerous people, plaintiff, suppose they die, so the suit does not abate, the suit can go ahead further. One more aspect that has to be considered, that is, the court does not have inherent power under section 151 of the code to implead the legal representative of deceased parties. Therefore, the proceedings to bring the legal heirs on record is comprised under Order 22 itself. So whatever remedies, either to set aside the abatement or making application for condonation, will have to be brought within the purview of Order 22 itself. You cannot make a separate, you cannot seek recourse to under section 155 of the Code of Civil Procedure for condoning the delay or setting aside the abatement. Now, there is also issue sometimes happens that when a person, whether a person who makes an application or who's brought before the court and there's a dispute between the legal aids, whether the such legal aids are the real legal aids on record, or they should be brought into the steps shoes of the deceased. In that case, whether a particular person or persons who are the legal aids, that question can be decided by the very same court under Rule 5. Now, as regards the order setting aside the abatement, there is a judgment of Supreme Court in Mithai Lal Singh versus Annabai Devram Kini. In that case, the court has held that inasmuch as the abatement results in denial of hearing on the merits of the case, the provision of abatement has to be construed strictly. On the other hand, the prayer for setting aside an abatement and the dismissal consequent upon abatement have to be considered liberally. The order setting aside an abatement does not affect the merits of the dispute between the parties, though it certainly determines the right and therefore does not amount to judgment. Order for restoration implies setting aside of abatement, even if there are no specific prayers. So this judgment citation is 2003 supplementary 3 SCR 822. On the last occasion also, I just need to mention here, I had cited certain judgments in this while I was discussing various provisions of CPC, and because I was going with a reasonable, not reasonably very fast, in that case, certain citations were not being able to, certain people are not able to note down those citations. In that case, what I have done, I will be sharing those citations after the conclusion of the present webinar in the group so that everyone can download and can make use of that. So this concludes as regards the abatement of suit and death, insolvency, and the marriage. Now I'm come to the new concept that is also taken into consideration in the CPC. What happens during the pendency of the suit? The plaintiff decides that I don't want to prosecute further. He may also decide, given the circumstances, that I don't want to go for all the claims. I will only confine my claim to a particular reliefs. And as far as the other claim or relief that I've prayed already in my plaint, I want to forego or withdraw. There can be also a possibility that during the pendency of the suit, parties come together, they arrive at certain consent terms, some agreement for the disposal of the suit. In that case, it could be, such consent terms could be either for the entire disposal of the suit. Second, parties can also build up any other matter or dispute which is extraneous to the subject matter of the suit. That also can be brought within the purview of the compromise decree, that is called consent terms. Or the parties decide that out of 10 items, parties are at ad idem. As regards only 7 items, 3 items the parties can still contest, and therefore there are, depending on the agreement arrived at between the parties, the consent terms or the compromise decree can be passed. Those provisions are contained in Order 23, read with Section 89 of the CPC. Now, the first part is withdrawal and compromise of a suit. As regards the withdrawal is concerned, there are 2 types of withdrawal that is contemplated under CPC. One is absolute withdrawal, and second is qualified withdrawal. If I go to court and suddenly, maybe after filing of the suit, I decide I don't want to prosecute, I want to withdraw from the suit, I don't want to prosecute for XYZ reason, then in that case, court has got no jurisdiction to object to the withdrawal. Defendants also cannot object that why he has filed the suit now if he had to withdraw the suit. In that case, leave of the court is not necessary. Objections of the defendant will be not fatal to the withdrawal. The plaintiff will be at full liberty to withdraw the suit on his own terms. That is one aspect of the withdrawal. Second aspect of withdrawal is where he wants to withdraw any part of the claim or relief against the defendant. For that reason, he will have to obtain the leave of the court. So, in a case of Bijayendra Patnaik versus Shatrughan Babu, AIR 1963, Supreme Court 1566, the court has said that right to withdraw suit against one or all of the defendants is an absolute right and not a qualified right. If the plaintiff does not want to proceed with the suit, certainly the court cannot compel the plaintiff to continue. So therefore, this summarizes the concept of the application for withdrawal and the right of the plaintiff to withdraw the suit. Then it also means takes into consideration the abandonment. Either you withdraw or you abandon part of the claim. If you withdraw the entire case incomplete. But if you want to abandon certain things, you can either abandon the whole suit or part of his claim. Or there could be also a possibility that if you arrange, let's say around 4 or 5 defendants, and you don't want to prosecute out of 4 defendants, you want to prosecute only 3 defendants, you want to leave the other defendants from the decree, you may also do that. It is your discretion and your risk, whatever you want to take. In that case, leave is not required. One more aspect is that in case of minor, if the plaintiff is a minor or a plaintiff person of unsound mind, because on the last occasion in the case of special suit, I had discussed what are the special provisions with regard to the plaintiff if he's a minor or who becomes subsequently or at the time of filing of the suit, the person of unsound mind. In that case, what all things he can do. Therefore, with regard to withdrawal of such suit, in such cases, without leave cannot be obtained, because ultimately court will have to take into consideration the interest of the minor, and such application for leave will have to be made by the affidavit of next friend or the guardian. And second thing, such application also will have to be supported by a pleader, that is advocate, with a certificate that proposed abandonment is in his opinion for the minor's benefit. So if the plaintiff is not a minor, he's got absolute right to abandon his suit or part of his claim, either against all defendants or with some of them, without leave of the court, no problem, and also supported by the citation which I just now cited above. Now, second thing, the only qualification which is there, an exception to the rule, is that in case the plaintiff is minor or person of unsound mind to whom that order 32 rule 1 to 14 applies, in that case, without leave of the court, you cannot abandon the suit or part of your claim. And the application will have to be made by of interim application. And what are the criteria? Obviously, when the suit was filed, the suit would have been filed by the next friend or by the guardian. So therefore, the same gentleman will be also here for making application as the applicant. And one more criteria has been also provided here, that the advocate concerned who is representing him should make a certificate that proposed abandonment is in this opinion, that is for minor's benefit. But it doesn't mean that suppose he makes an application and the certificate is given by the advocate, the court will blindly follow such the application and will allow the withdrawal. It is not like that. It is a judicial order, and whenever, as we all know, that wherever the court has to pass any order, there's a duty cast upon the courts to apply his minds and be very reasoned, and from which we can ascertain that the court has made a proper order, and the purpose for which the leave was granted or leave has been refused has been granted with complete grounds given in that. Now, second thing is, now earlier I've talked about the suit, withdrawal of the suit without leave. Now, this is called qualified withdrawal, second provision, that is withdrawal with leave of the court. That these are the circumstances where, suppose I file a suit in the court, at that time maybe I've come to know that this particular court suit should not have been filed in this court. It should have been filed elsewhere in some other court because of lack of jurisdiction, or there could be some formal defect, or there are sufficient ground for me to institute fresh suit for subject matter of part of the claim. Then in that case, I will have to apply to the court for a permission to withdraw the suit with liberty to file fresh suit. And in that case, the court will grant such liberty on such terms as it may think under Rule 1. But one thing is very clear: if a suit has been filed and based on the formal defect, or there are sufficient ground for me to institute a fresh suit for the same subject matter or part of the claim, and if I withdrawn the suit without the permission or the leave of the court, that is called normally called as liberty, with liberty to file, to withdraw the suit. Sorry, with liberty to file a fresh suit. In that case, if no such liberty is granted by the court, a fresh suit cannot be filed later on. Now, there are certain explanation what could be the formal defect, what could be non-formal defect. So, rule 1 says that if there is a formal defect and the plaintiff wants to correct those defects, in that case want to file a fresh suit, or sometimes court also says because of some kind of XYZ reasons, the plaintiff realizes that he made a big mistake and he should not have filed it, and then he needs to correct those mistakes. He can do that. But if the plaintiff has filed the suit and in the plaint there is formal defect, then in that case the liberty can be granted and the plaint can be withdrawn. But if it is non-formal defect, if you have, for example, let's say non-joinder of necessary parties, not including all causes of action, because when you file a plaint, you have to assert your right. All the rights, reliefs that is accrued to you should be also taken into consideration. You have to make all pleadings. But if you make a kind of a big blunder, by, for example, let's say you've filed a suit for, you have not joined the necessary parties, you have wrongly sued somebody else, or you have not included all the causes of action, because we know that under order 2 rule 2, if in respect of any relief that we want to abandon and the leave is not granted under order rule 2, then we can't later on file a fresh suit. And suppose here we don't obtain a leave under order 2 rule 2, we proceed further and we realize that later on I should have included this ground also as a part of the said relief, and no rule was granted, no leave was granted under order rule 2, I can't proceed further. Secondly, if the plaintiff is a partnership firm, it's unregistered, and in that case also you can't do that. So it will be treated as non-formal defect. Then court will not allow. Secondly, if there's a bar of limitation, or there's a deliberate undervaluation of the subject matter of suit, or maybe at the time of filing of the suit, failure to bring the legal aids on record was not taken into account. All these things are formal defect. Therefore, such defects will not permit you to withdraw the suit, and no liberty will be granted in most of the cases. Now, if the effect of if the leave is granted to you, to the plaintiff, what can happen? It can be granted either on application of the party. Sometimes plaintiff realizes that he made a mistake, or sometimes court may sumo take an action, and they advise the plaintiff that we all see in the daily course of our attendance in the court. That court also sometimes says what options you have now, what you wish to do, whether I dismiss the suit or withdraw, or you want to withdraw. In that case, they may take that decision on that I would need to withdraw the suit. Now, certain rules that we need to consider with regard to withdrawal: if there are 2 or more plaintiffs, the suit cannot be withdrawn without the consent of all parties. Secondly, after even if the leave has been granted, now you want to come again, you can't say, and by the time you file a fresh suit, at that time your claim is barred by law of limitation. In that case also, you will be debarred from prosecuting case because of the bar of law of limitation. So that risk also the plaintiff runs. And this order also applies to the appeal. For example, let's say the appeal has been filed and there also some kind of the defects or formal defects has been discovered. The court permits withdrawal with liberty to file appeal. It also applies to the Article 226 and Article 32, those petitions which are filed under the Constitution. These rules of withdrawal also applies to the those proceedings. But these rules are not applicable to execution proceedings under Rule 4, because once you have already obtained the decree and you have already started the process of execution of decree, then you can't go back. You withdraw it, then you can't say, okay, I'll later on, whenever the need arises, I will come back. So once you withdraw your execution application, then you can't do. And there is no such provision for granting a liberty to withdraw the execution proceeding with liberty to file a fresh execution proceedings. There are certain eventualities also may take place. For example, let's say the suit has been filed and the plaintiff has made an application for withdrawal, and there are more defendants, and eventually it may happen that some of the defendants think that the plaintiff is getting out of the suit, maybe I should prosecute the suit, because sometimes what happens, I'll just give an example. In a case where one of my client had filed a suit for partition against certain defendants who are the other legal heirs. One of the legal heirs of my client's branch of family was also having internal dispute with their siblings, and therefore, since that person did not come forward to join as a plaintiff, therefore, as a matter of prudence, because obviously he's also a necessary party, he was made a defendant. Now, suppose out of 4 plaintiffs plus that defendant who's also part of the same branch of family to which the plaintiffs belong, 4 plaintiffs decide to withdraw the suit. Obviously, that defendant who's also branch of the very same family, his rights will get affected. Therefore, there's a provision given here under Rule 1A that defendant can apply to the court. Look, that suit is filed for a partition. Partition has to take place. Therefore, let me become the plaintiff and prosecute the suit further. And in that case, he will be transposed as plaintiff. That's called transposition of parties. So that defendant will be transposed as the plaintiff and the suit will further proceed. Okay. Now, if withdrawal application has been filed and someone wants to challenge the withdrawal, no appeal lies, but revision is permissible depending on the facts of the case. No formal application is required for withdrawal. It may be withdrawn by filing precipi under notice to the defendant, though notice is also not required, but as a matter of fact, as a prudence, as a practice, it is necessary that you must give the notice to the other side and court will take into consideration. Sometimes court will also take into consideration that in order to withdraw, whether the advocate who's making application for withdrawal has got certain mandate from the plaintiff or the concerned officer of the plaintiff, in case if it is a other juristic entity, then in that case court will also try to satisfy itself that the necessary mandate is also brought on record. Or sometimes the plaintiff or the concerned person who represents the plaintiff is also remains present in the court, and that's how the proceeding goes away for withdrawal. So that closes the chapter as far as the withdrawal is concerned. Now, coming to the compromise of the suit, as just now at the start of my discussion, I just had said that during the course of proceedings, there could be an eventuality where the plaintiff decides to withdraw. But as we all know that once the suit is filed, invariably the parties also simultaneously start discussing about the compromise or discussing the way forward, how to resolve the dispute. So the resolution of dispute can happen either for the entire suit or for certain more matters or dispute which is not part of the subject matter, that also can be brought on record. And one more thing is that instead of out of 10 items which are in the litigation, parties say, okay, if as regards 10 items, we can have a kind of agreement or adjustment for 4 or 5 items, and the remaining items can be we can prosecute further. The suit can continue for the remaining item. So let's have some kind of understanding with regard to 4 items for which some consensus has been arrived at. So therefore, such kind of agreement is reduced into writing, and then we know that such kind of we call in our actual practice as consent terms. We file the consent terms in the court, and the court looks into the consent terms, ensures that all the parties to the consent terms before the court, and in that case consent term is taken on record, and such kind of, if the entire suit has been worked out in view of the consent terms, the entire suit will be disposed of, either dismissed as disposed of in terms of consent terms, or that's how the actual practice takes place. Now, what is the condition for a compromise? Obviously, compromise cannot be oral. It has to be in writing, signed by the parties, and it should be lawful and recorded by the court. That is the crux of the matter. So, lawful means what? Ultimately, if it is an agreement, if it is a contract, therefore, the provisions of the contract, for example, free consent, there should not be it should not be, there should not be any fraud, there should not be any misrepresentation. All those provisions of the Contract Act which validates a contract or which does not invalidate a contract on account of fraud, misrepresentation, undue influence and all that. So if that compromise decree, compromise agreement which is arrived at between the parties can be considered to be lawful and it is found by the court to be lawful, in that case court invariably does not get into that and disposes of the suit in terms of the consent terms. Once very important aspect about this is that once consent decree has been passed, no appeal can be filed by any party, because the parties have already agreed that based on certain terms and conditions, the entire discussion has taken place and order has been passed. It has reached finality. No appeal can be passed except that those provisions which are applicable for declaring the contract as void, those or voidable under the Contract Act, can be taken as ground to set aside the compromise decree. So, but it is not easy. But the fact remains, those provisions can be taken into consideration that it was done by some fraud or misrepresentation. Those provisions can be considered, but only on those grounds, not otherwise. And Rule 3A is very important. It says that no suit shall lie to set aside a decree on the ground that compromise was not lawful. However, suit can be filed to set aside the compromise decree on the ground of fraud, undue influence and coercion. There is a authority on this in the case of Slibachin and others versus State of Tamil Nadu, Superintendent Engineer and others, 2015 5 SCC 747, where instead of parties, one party was represented by the council and he made a statement and he put the signature on the compromise decree or the consent terms. Both are synonymous. So he had signed the consent terms on behalf of his client, and in that case, once later on the client himself tried to set aside the consent terms, the court had given a very detailed order as to reasons why the authority given to the council was valid and could not be declared to be lack of authority, and it was binding on his clients, unless of course from the contents or from the manner in which the such kind of consent terms were drafted, we can question the ability or the discretion or the judgment or the manner in which the council has or the concerned advocate has acted. If it can be decided that he acted beyond his scope, in that case obviously the court will definitely look into those aspects. Otherwise, even the council also can, with the implied authority, sign the consent terms. But however, as a matter of prudent practice, one should not sign on behalf of the consent terms without the plaintiff for whom or the clients whom we are representing, their signature also should be there. And in also, if they are represented by some or clients are some kind of a legal entity, non-person, in that case obviously the resolutions required also has to be attached as a part of the consent term, so that ultimately nobody can question the consent terms or apply for the setting aside. That's very important. So therefore, now second thing is that whether the breach of consent terms amounts to contempt. It says that if in the consent terms there are certain undertakings are inbuilt and those undertakings are accepted by the court, then it becomes an order of the court, and such order of the court will have to be abided the way it as stands, and the court will definitely can hold the person liable for contempt if any proceedings for contempt is launched against the person who does not abide by the consent terms, especially with regard to the undertaking which has been given to the court. So therefore, normally in all consent terms, all the crucial obligations of the parties we have to take into consideration that we should put in the form of undertaking, number one. And when the order on the consent term is passed, disposing of the suit, we have to request the court that as regards the undertaking which is comprised under the consent terms, the court has to record specifically that all undertakings given in the consent terms are accepted, so as to enable us to put up more leg if the other side or any parties to the consent terms try to commit breach. In that case, apart from enforcement of the decree, of the compromise decree, we can also prosecute him we can hold him for contempt. Now, this is a provision as regards section 80, section 22 of the 23 of the Code of Civil Procedure. Apart from Order 22, there are certain other provisions also contained under CPC. One was amended in the year 1999, which came into effect from 1st July 2002 in the form of section 89, which was substituted or replaced by the earlier section 89. The relevant portion talks about that when it appears to the court that there exists an element of settlement. So normally, without the application of section 89, I had already discussed, the parties themselves agree to certain compromise. In that case, that compromise can be recorded and the court can formulate that consent terms in the form of a decree, and the court can proceed further, and that becomes a binding decree. Apart from that decree being binding on the parties, it also prevents any of the parties to deviate from the consent terms on the basis of estoppel, because on the basis, suppose I promise somebody and based on the promise other side is acted, in that case I can't do something by which the other side has to alter his position. So that estoppel also works on the enforcement of the consent term. Now in 89, section 89 of the CPC, which has been inserted in 89, the court has got powers if it appears to the court during the tenure or during the pendency of the suit that there exists certain elements of settlement which may be acceptable to parties. The court can formulate those terms of settlement and give them to the parties for their observation. And after receiving the observation of the parties, the court may formulate those questions and refer the matter for conciliation, judicial settlement through lok adalat and mediation. So therefore, the settlement provisions and compromise, these things also can, section 89 also can be resorted. Now, coming to, there's one more provision which also can be referred, depending if the question comes that what are the provisions with regard to the compromise. You can refer to order 22, order 23, sorry, you can order 23 you can refer to. You can also include the provision of section 89 and order 10, more particularly rule 1A, where based on the admission of denials, rule 1A of order 10, which deals with the examination of parties by the court. It says that after recording admission denial, the court shall direct the parties in the suit, because there's a stage of admission denial also takes place. And if the parties, if it comes to the conclusion the other parties have accepted your case, there's no point in going ahead with the suit. In that case, court records, and then he may ask the court to go for out of settlement case, and the parties can, and then court can intervene and take into consideration and prevail upon the parties to arrive at some kind of settlement. So therefore, this is a question of compromise. Now I'll come to the next topic, which is the most important and which applies to all cases, because ultimately whenever the cases are filed, it is to be decided by a judge. Obviously, judge will apply his mind, and whatever discretion or the mind of the application of mind he applies, it may not be necessary that somebody, either plaintiff or defendant, depending on in whose favor the matter has been, the decree or the order has been passed, the person against whom the order has been passed, obviously he will be the one who will be more prejudiced, will be more aggrieved. He will definitely be inclined to go to the other court for challenging the orders. So therefore, so I'll be discussing now appeal, revision, review, and reference. These are the 4 different areas of challenging or going to the higher forum for adjudicating the dispute which is pending before the trial court or the court below. Before I begin, I would like to just quote one American Supreme Court judge, Robert H. Jackson, which famously had said, "We are not final because we are infallible, but we are infallible only because we are final." And this observation was also reiterated by Chief Justice of our Supreme Court, Mr. Y.T. Sabharwal. He's also said that just because we have given a degree or any adjudication, it may not, we also prone to human error. And therefore, the question that arises out of this kind of concept is that ultimately, to any matter which is before the court has to apply his mind, but judicial reasoning, whatever the standards which are available to the court, keeping in view of the matter before him, and also the precedents of the authority of law, the precedents, everything that court has to take into consideration. But there's a high chances, or there are chances, obviously the other side might think that obviously the court has not applied his mind, therefore I'm agreed by it, therefore I need to challenge it. So those challenges are called appeal. Those challenges also could be in the form of revision, review, and I'll just come to each one of them. Now, coming to the appeal. Appeal is basically a right given to the litigant under the statute. For example, if the right to appeal is not given under the statute, then he cannot file any appeal. Then it's not that he's become remedialist, he can't go anywhere, but definitely he can go to the other provisions. Sometimes he can prefer a writ petition against the order, because we'll say that I've got no other remedy, efficacious alternate remedy. Under 226, he can go ahead. I'm not looking at 220C right now. The only thing I have to confine to right to appeal. So therefore, it is important that when a person has to go for an appeal, he has to ensure that the right to appeal is enshrined in the code itself, or any other provisions for that matter. In the case of Srimati Gangabai versus Vijay Kumar, AIR 1974, Supreme Court 1126, this clearly says that right to appeal is statutory and a substantive one. And second aspect about this is that this law has to accrue on the date of institution of the original suit. For example, if in the year 99, I filed a suit, and that time I had a substantial right, there was a provision under the CPC that against this particular order, if any decree is against order or decree, if there's an appeal provided for in that case later on, maybe at the time the decree is passed, that right has been taken away because of certain amendment in the Code of Civil Procedure. That right cannot be taken away. My right still remains subsisting because it was subsisting as on the date of filing of the suit. So these 2 points has to be borne in mind. One, the appeal is a statutory right and is a substantive right. Second, this right accrues on the date of institution of the original suit itself. And second aspect is, now, what are the provisions with respect to appeal? Appeal could be appeal from decree, appeal from order, appeal from judgment. Appeal from, they are comprised under section 2(2) of the CPC. 2(9) is the order judgment, and 2(14) is the order. Section 96 to section 111 are the provisions which provide for the appeals against decree and order, and order 41 to 45 deals with the appeals to various authorities, various judicial forums, appeal to Supreme Court, second appeal, first appeal, second appeal, appeal to Supreme Court, and there are High Court side rules and appellate side rules that I will come to when I'll be discussing various classification. So now coming to the appeals, it has got two classification. One is first appeal and is second appeal. Again, in the first appeal, there are further sub classifications. First classification is appeal from original decree. That is, I just now said, section 22, 229, 96 to 98, 99A, order 41, chapter 40, High Court rules 744 to 746, and High Court rules 876 to 909 are these provisions which deal with appeals from original decree. Second would be appeal from appellate decree. That will be there in section 100 and 101, section 100 to 103 and order 42. Then appeal from orders, often titled as they are there in section 104 to 106 and order 43. And then there are certain things which are not order per se, but they are treated to be a decree. They are called deemed decree. And there is something called Letters Patent Act, where the letters of patent appeal is we need to discuss. There's another branch of law, because since we are in the Honorable High Court of Mumbai, where we are also governed by the Letters Patent Act, and therefore there's a certain provisions are also we need to take into consideration. Then there are appeals to civil court from various orders or decrees passed by various judicial and quasi-judicial authorities under various statutes. Those appeals also we'll have to discuss. Then second is appeal by indigent person. On the last occasion, I discussed that if the suit is by indigent person, that means the person who does not have means to even or does not have a property more than 1,000 rupees. And suppose in that suit or subsequently the person becomes indigent, in that case, there's a separate provision under 44 about the appeal by the indigent persons. And then there are certain general provisions relating to appeal. They are comprised under section 107 and 108. And then there is something called appeal to Supreme Court, which are mentioned in section 109 to 112, order 45. Then we also have order article 132 to 133A and 136 of the Constitution of India. Then High Court rules, chapter 43, High Court rules 910 to 923, and there is a form given in case of certificate of fitness that I'll come later, form number 93. Now let's come to immediately the first topic, appeal from original decree. Now appeal from original decree is that when a person is agreed to any decree which was passed by a court exercising its original jurisdiction. So therefore, initially when a suit is filed in the original jurisdiction, for example, normally plaint is filed either in the small causes court, in the city civil court, in the high court. In that case, the trial will take place and ultimately the final decree will be passed. And in that case, if a decree is passed, that is called a decree that can be appealed from. And second thing is section 97, section 98, section 107 or 102 of the CPC enumerate certain conditions under which no further appeal is permitted. So therefore, these provisions talk about you can only file only one single appeal. That means first appeal, it is popularly called as, you can't file a second appeal. But I'll come to that. If you are precluded from filing first appeal, definitely you can file writ petition or revision. Those things depending on the case involved. Now, who may file an appeal? Obviously, the person who is adversely affected by the decree will be the person. Second, if the person who is adversely affected by the decree and that person expires after passing the decree, his legal representative can come in place under section 146 of the CPC. There's a judgment, Baldev Singh versus Surinder Mohan Sharma, 2003, 1 SCC 34. I am going to give all the citations at the end of the webinar. Then in that case, maybe that can be taken into consideration if I'm going very fast and any of the participants are not able to note down these citations. Now, as I said, so the person who's adversely affected by the decree is a person competent, or is legal heirs in case of the person is died. Second, any transferee of interest of such property. Suppose I have got a decree and later on I sell the decree. For example, I can assign the decree to somebody, he becomes a transferee of my interest. For example, there's a decree obtained in respect of a sale of property. Later on, that property itself or during the proceeding of the suit has been sold off to some other person. So that person steps into the shoes of the decree holder. In that case, that person also, because such decree will definitely affect his rights, so he also becomes competent to file the appeal. Second, an auction purchaser may prefer an appeal against order in execution. For example, any property which has been ordered, which is subject matter of the dispute in the trial court, and that actual subject matter, the suit property that we call as, has been later on sold in execution of the proceedings. In that case, that person also make an appeal for setting aside the sale on the ground of fraud. Now, general rule is that no other person unless he's a party to the suit. That is a general rule. But transferee of interest and auction purchaser, these are exceptions to the rule. And there is a judgment also Jatan Kumar Gulcha versus Gulcha property, 1977, 3 SCC 5C3 573. In that case, court had held that a person who's not a party to the suit may prefer an appeal from a decree if he is bound, aggrieved, prejudicially affected by some, and he has to make a separate leave of the court. So therefore, even a third party, because of this judgment, the court has permitted such person if he is bound by the decree, agreed by the decree, or prejudicially affected by such decree. Now, as we all know that in a case which is highly contested and trial has taken place, the decree has been passed. That is a decree in general under section 2.2 of CPC. There could be a possibility that the other side does not come forward and the ex parte decree has been passed. That is also a decree which can be validly enforced. But with regard to the setting aside the decree, there are various provisions which are there in the CPC as well as in the decided cases depending on the citations, that what are the remedies which are available to a person against whom the decree has been passed in his absence or in the absence of any appearance or for want of filing any proceedings under order. So therefore, first provision that is there, which is most efficacious and fast, to go to the very same court to make an application by of notice of motion, now in interim application, by to apply for setting aside the decree. That is one ex parte decree, setting out the grounds why he could not remain present, what was the bona fide the reason for which he could not remain present or he was prevented from attending to the court on the day when the decree was passed. Second remedy that he will have to file an appeal under section 96(2) of the CPC. Third, if against such order no appeal lies, still he is not a remedialist, he can still file a revision under section 115 of CPC. He can go to the very same court for review of the order under section 47(1), or in the alternative, suppose later on he comes to know that the decree has been passed and it was passed by the plaintiffs at the instance of plaintiff by playing fraud on the part of the court, for example, without serving the proceedings or the writ of summons at some other place which is wrong place, which was not never the address of the defendant. He can tell the court that the plaintiff has played fraud on the part of the court and has obtained a decree by misleading this honorable court. Therefore, you can file a separate independent suit to set aside the decree on the ground of fraud. Now, whether all these remedies or the options or the provisions which are there for to set aside the decree are to be taken one by one, or one you take one, you can't take other. So these are things are there. The court in one of the case, Bhanu Kumar versus Archana Kumar, 2005, 1 SCC 787, the Supreme Court has said the above reliefs or the procedures which are given are concurrent and can be exercised simultaneously. So therefore, the court has held that these remedies are available. Either you can go for one of these remedies, whichever you find convenient, or you can take one or more of such remedies depending on the facts and circumstances of the case. Now, I've just discussed when the appeal lies. Now let me also discuss when the appeal does not lie. The first, I had also said that if there are no provisions, there are no right is conferred upon you or under the statute, you can't file an appeal. That's one. Second thing, I had also discussed earlier while I was discussing the compromise of the suit under order 22. There I had said that if the order has been passed based on the compromise arrived at between the parties, then also such kind of order cannot be appealable. Same thing has been brought here also under section 96 subsection 3 of the CPC, saying that if the order is passed against consent, you cannot file an appeal. That is called appeal against order. And 96(4) says if the subject matter of the claim does not exceed 10,000, then also you can't file an appeal, because it becomes purely academic and waste of the time of the court in entertaining such appeal. In that case, these are trivial matters, petty cases, the appeal cannot be filed. However, there is an exception if it is a matter of law. Obviously, the question of law definitely will have to be decided. That will not be scuttled down by the claim or the amount, whether it is 10,000 or less than 10,000. Second, an appeal cannot lie against a mere finding. if there is no decree passed. For example, suppose in a day-to-day business, there is a, let's say the decree has been passed for in favor of the plaintiff on the ground that the suit should be dismissed because it is barred by limitation. But at the same time, the court also records that although in my view that the defendant is required to pay the money, he is liable to make the payment, but since the claim of the plaintiff is barred by law of limitation, therefore I am dismissing the suit. Now what has happened? As far as the plaintiff, his rights are foreclosed, but defendant, because there has been an adverse remark against him, he can certainly go to the court of law, file an appeal under order 41 rule 40 or 22, and he can also assail such adverse finding. So therefore, if second aspect, suppose there's a certain observation is made, and based on such observation, the decree cannot be the decree is not affected by such observation. In that case, these findings cannot be. So, for example, in the case just now I cited that the case has been disposed of on the ground that the suit is barred by limitation. Plus also there's another thing, another finding that the plaintiff, there's certain finding against the plaintiff's conduct. So definitely that conduct is not resulting into the decree. Therefore, you cannot file an appeal against the finding which is completely not appealable. Second bar on the filing appeal is that in case of preliminary decree, because that's how it was discussed by other colleague at the time of discussing the decree. There are different types of decrees, preliminary and final decree. In case of preliminary decree, if it has been passed against the defendant and the defendant does not challenge the preliminary decree, and later on based on that preliminary decree, the final decree has been passed, in that case, the order passed as a preliminary decree cannot be challenged. This is another embargo which lies in case of the person who wish to challenge the preliminary decree. Now decree has been the appeal has been preferred. It has gone to the higher forum, the appellate court. And appellate court, let's say there are two judges who are sitting, and in case they differ on the question of fact. Suppose there are two judges who are sitting. I'm discussing now section 98(2) to make you understand. If there are two judges sitting in the appellate bench and they differ on the question of fact, so therefore that means obviously when they differ between two judges, one judge is in favor of the decree and other one is not in favor of the decree or the grounds of decree. In that case, now we have three judges, one judge of the trial court, and two judges. One is in favor of the trial court or trial court order, and one is against the trial court order. So therefore, in total, we have two judges, one from the trial court order and one from the appellate court order, who are favoring the judgment on the question of fact. So therefore, in such an event, irrespective of the difference of opinion between the two judges of the appellate court, the decree will have to be still upheld as final. Second, so therefore, notwithstanding the difference of opinion between the two judges and the another bench who's differing, who's not supporting the view taken by the another member of the division or bench, in that case, that his disapproval will be completely insignificant, because the original trial court's opinion on question of fact, finding on the question of fact, plus the appellate court's one member upholding that question of fact, in that case they'll be treated as a final and the appeal will be set aside. The decree will not be set aside. However, so therefore the principle is that as far as the finding is concerned, the division bench or the appellate bench sitting two judges cannot get into the fact finding with regard to the finding which the trial bench has already arrived at. Now, second aspect is that question of law. So if the matter comes to the appellate court, let's understand there could be two items. One could be the difference on the facts and the difference on the question of law. If there's a difference on the question of fact, In that case, such decree will be upheld as absolute. But if there is a difference on question of law, in that case, they will have to refer the matter to a third judge, and ultimately the opinion of the majority of the judge on the question of law will be the final, as and that will be decided as a final verdict. Now, section 99 says what are the rights or what are the powers of the appellate court. The first thing, at least, they say what they will not do. Section 99 says the appellate court will not reverse or vary a decree or cause a remand on account of any misjoinder or non-joinder of parties or causes of action of any error or defect or irregularity not affecting the merits of the case. That means if it is a petty matter not affecting the merits of the case, in that case, the appellate court will not intervene. For example, defense of territorial jurisdiction, defense of pecuniary jurisdiction. Suppose the other side has taken an objection with regard to the territorial jurisdiction, with regard to the pecuniary jurisdiction, and the court has upheld and gone ahead and reversed the decree. In that case, the appellate court will not look into such kind of objections. Now, coming to the second appeal, I think I'll also discuss what are the limitations which is provided on under the Article 117 and 116 of the Limitation Act. In case the appeal has to be preferred within the before the High Court, in that case the limitation is 30 days to file an appeal to High Court, as against the period of 90 days to file appeal from the original decree passed by the subordinate courts under the Limitation Act 1963. Therefore, the section provides for a special period of limitation of only 30 days to file an appeal to High Court, as against the period of 90 days to file appeal from original decree passed by the subordinate courts under the Limitation Act. So therefore, if it is a subordinate court and you want to come to the High Court, you have 90 days. And if it is only High Court and you want to go to the appellate court, then it's only 30 days under Article 116, read with Article 117 of the Limitation Act. Now, it is not that, obviously we all know that if there is a if the appeal is not filed preferred within the timeline that is given, in that case section 5 of the limitation will have to be looked into, where the court says that notwithstanding the period of limitation provided under the Limitation Act for filing appeal, the delay in filing the appeal can be still condoned provided you are able to make out a sufficient cause. What is sufficient cause? There are plenty of judgments for condonation delay. That is not the subject matter of present discussion, but definitely one has to look into to understand as to how the appeals are entertained after the expiry of the limitation period. Now, second aspect, we discussed about the first appeal, that was appeal from order, appeal from decree. Now this is second. Now the first appellate court has passed the order, so that becomes appellate decrees, and against the appellate decrees you want to prefer a second appeal, is called second appeal. Now, what are the criteria? Because whatever have been the ground of in the first appeal cannot be the same ground to in the second appeal, because then it has to be curtailed down at some point of time. So therefore, that's what the section 100 to 103 and order 42 of which it deals with the second appeal. I'll first come to the section 100 of the CPC, which says that an appeal shall lie to the High Court for the decision made by the district court. That's one. An appeal lies if the decree is passed ex parte. So therefore, the provision is given. Even if the decree is passed ex parte, still you can file a appeal, second appeal. If the High Court is satisfied, now the third degree, if the High Court is satisfied that the substantial question of law is involved, then it shall formulate the decision those decisions. So, what is the difference between the first appeal and second appeal? Let me just make it very clear that the very difference between the first appeal and the second appeal is that first appeal is available as a matter of right on any ground involving the issue, fact finding, the manner in which the entire pleading has taken place. So it's basically the appellate court sitting in the first appeal will take the entire case as it is and will try to decide whether as if he's sitting as a trial court. But whereas second appellate court will not look into the entire thing, except that if any issue or any judicial discretion has been exercised which involves the substantial question of law. Now again, as I have already told that right of appeal has to be provided by the statute, same thing also applies to the second appeal. It has to be provided by the statute. There is no inherent power of the court to entertain the second appeal. Then right starts from this again, as in the first right of appeal starts on the day when you file the suit. That means again I have said that if on the date of filing of the suit right of appeal was in existence, and later on because of amendment that right to file an appeal was taken away, it is of it will be of no consequence, because if the first right of appeal was in existence at the time of filing of the plaint. Similarly, also can be inferred that the second appeal also can be maintained on the very same basis, because the second appeal was right to file second appeal was also in subsistence at the time when the suit was filed. Okay. Now, as I already stated, the only two grounds which are important for filing the second appeal: number one, question of law, and second, the question law should be substantial. And secondly, if the question of fact which has been wrongly determined, that is not the criteria, because it is not the job of the appellate court sitting in the second appeal to get into the factum of the dispute whether any question of fact was wrongly determined or not. This court will not look into it. But there are certain rule of procedures. If the court does not follow, if the trial court had not followed, in that case, even if the court can look into the facts of question of fact, provided it was taken into consideration in the manner which ought to have been appreciated. I'll come to that. So the earlier had said that as far as the first appeal is concerned, the petty cases cannot be taken into consideration for filing appeal, which are below 10,000. Similarly, we have a provision under 102, which says that the original subject matter of the original matter did not have money. The subject matter was less than 3,000 rupees. Then obviously second appeal will not lie, even if it is a matter of question of law. So 102 of the section 106 to section 102 says that no second appeal lies in any suit of the nature cognizable by the court of small causes court, if the amount of subject matter of the suit is not exceed 3,000 rupees. Therefore, in case of small causes court, if the subject matter of the suit is original suit which was filed as on date of filing of suit does not exceed 3,000, second appeal cannot be filed. And then there's a case law on this, which Jagdish Singh versus Naithu Singh, AIR 1992, Supreme Court 1604, which says that if the court is satisfied that the finding of the fact by the lower court was vitiated due to non-consideration of relevant evidence, because earlier I had said the under second appeal, the only fact which needs to be considered is the question of law, and whether it is substantial question of law that needs to be decided. So therefore, and whether any fact was rightly applied or not rightly or wrongly applied will not be taken into consideration for deciding the second appeal. But if in this particular citation, AR 1992 SC 1604, it says that if the appellate court, that is appellate court handling the second appeal, is satisfied that the finding of fact by the lower court was vitiated due to non-consideration of relevant evidence, or consideration of evidence or finding of the fact which has been perverse, then obviously such kind of then one can take such kind of as a ground to take up the second appeal. It will have to be considered. Now, power of High Court to determine issue of fact. Section 103. Under what circumstances the power of High Court can determine the issue of the fact? It says that if the evidence of record is sufficient, in the second appeal, High Court may determine any issue necessary for the disposal of appeal, number one, which has not been determined. So therefore, any question of any fact, evidence, which has been not determined by the lower appellate court, or both by the court of the first instance or the lower appellate court. So first appeal, the question of evidence, the evidence was not appreciated, or the evidence has been wrongly determined by such courts, and in that case, the court will entertain such kind of grounds as an appeal for in the second appeal. Now, what is substantial question of law? That is also a subject matter of various judgments. But I'll just cite one judgment which says that that is Heroin versus Sheshammal. It's a Supreme Court judgment again, 2006, 5 SCC 5 page 545. It says that a substantial question of law arises when the court below has ignored material evidence or acted on no evidence, or have drawn wrong inferences from or proved fact on erroneous application of law, wrongly cast a burden of proof, or where the evidence taken as a whole is not reasonably capable of supporting a finding which has been rendered by the first appellate court. So therefore, obviously the first trial court would have done the same mistake. The appellate court also, first appellate court also has done the same mistake by not applying the evidence which are brought before the appellate court. In that case, the court handling the second appeal can get into the such kind of the matter, and this will amount to substantial question of law within the meaning of section 100 of the provision of the CPC. Now, the High Court says that because when the matter comes before the appellate court, he has got all the powers of the trial court. Similarly, second appeal also the very same power, because he sits in the first appeal, and therefore he has also power to admit additional evidence with regard to any other matter which had remained to be decided. So that power in the second appeal, High Court has that power. And then so that concludes as far as the ground of appeal with regard to appeal from decree. So decree, appellate decree, first appeal, second appeal, that I already dealt with. Now, order. There's a second category that is called order. That is there in section 104 to 106 and order 43. Order 43, as I said, any appeal has to be provided for in the statute. If it is provided, then you can go ahead with the filing of the appeal, otherwise not. So now, as regards the order appeal from orders, only those orders can be appealed which are provided in the statute. Which are those orders? Under the CPC, various orders are passed during the process of adjudication. Order 43, Rule 1 has got a comprehensive list of various orders passed under various sections, various orders of CPC. Those can be covered under the appeal from order. And in addition to those provided under Order 43, Rule 1, there are certain provisions. For example, an order made under Section 35A, compensatory cost. Now, order under 95, compensation for obtaining arrest or injunction. And then those provisions can be taken. So now, as far as 104 is concerned, Section 104, it says that only those orders can be appealed, an order can be appealed against which are provided under 43 and not against any other order, number one. Second, it also says that save as otherwise expressly provided in the body of the code. So body of code is order 43 or by any other law for the time being force. Normally when the courts take up the matter, they also don't apply all the time, are only dealing with the proceedings arising out of the CPC or the general laws. There are certain other sometimes other the statutes which are also sought to be enforced in the proceedings. In that case, those laws also might be having certain separate provisions. So therefore, it says that for either those orders can be appealed from, or those orders which are there provided in respect of those orders which are contained in other statutes where there's a provision for appeal against the appeal from order. So those things also can be covered. Now, the list is there, as I said, that is order 43 Rule 1. It's a comprehensive list, plus any other statute which provides an appeal from order, those also needs to be considered. Now it says that under section 106, it says that where an appeal from an order is allowed, it shall lie to the court to which an appeal would lie from the decree in the suit in which the order was made. For example, if decree had been passed and the very same court had for example, suppose the trial court has passed the order, and if that court had passed the decree, wherever the appeal would have gone against the decree, the very same court would be the appellate court for the purpose of entertaining the order. That's what the clause says. Now, as far as the limitation is concerned, again, the limitation is contained under 30 days and 90 days under Article 116 and 117 of the Limitation Act. Now, as far as the stay is concerned, whether it's a decree or the order, if it has been appealed from, the merely filing of the appeal by itself does not amount to automatic stay of the order. Therefore, couple of things can be done. First, make an application to the trial court itself. That is the best thing, that please allow me whatever time frame that is given to me under the statute to enable me to file an appeal. So you allow me that. If the trial court himself gives the time for you, times to you to file the appeal within let's say 3 months. So obviously, and in the meantime, the operation of order should be stayed, and the court agrees to that. He grants you 3 months. Okay, within 3 months, this particular decree will not be executed. This order will not be implemented. So it's virtually a stay. Otherwise, if the court refuses, the trial court does not give such kind of stay. In that case, while filing an appeal, you have to make a separate application for interim stay, depending on the format that is provided. In the case of civil appeal, there is a civil application. In the case of original side matters, earlier notice of motion, now interim application that also can be filed along with the appeal, irrespective of the merits of the matter in the appeal, for the purpose of deciding whether the stay should be granted or not. That cannot be the sole ground. For a stay, a separate ground will have to be made out which are more or less on the principle of very same principle on the basis of which the temporary interlocutory orders are generally passed, or depending on the circumstances of the case. Now, what happens? The procedure is very simple. When the appeal is filed, the court fixes a time for hearing, and then in that case, the notice is given to the other side to come back, and on that day, the summons are issued. Based on that, the respondents will come, a date will be fixed, and that proceed, and the matter proceeds further. And then I just said that in case the appellate or the person who seeks to appeal against the order, or exercises the order, or exercise the right to appeal, is an indigent, which has got a property less than 1,000, does not have sufficient means. In that case, provision is contained under order 44. That says that if the person is not able to do it, file an appeal. In that case, he has to make an application supported by. So therefore, his memorandum of appeal, because appeal has to be filed by memo of appeal. That's what is called. So along with the memo of appeal, he'll also have to make an application stating that he should be declared as he should be considered as an indigent person. And in that case, the court should, there are certain procedure which is given, and the court the court is convinced that the person cannot afford the cost of the appeal or the litigation involved in the appeal, in the second appeal, and court can direct any authority on the authority of the court, government pleader or the respondent or any other person, to take up that case and take it further. And if the court decides that the person has been allowed to proceed as an indigent person, and somebody else gets steps into the shoes of that person, in that case, what happens? The proceeding follows. Now, general provision relating to appeals. So, who can file the appeal? What are the grounds for filing the appeal? First appeal, second appeal, the appeal from order that I have just now narrated in the earlier. Now, coming to the second thing. Now, when the matter comes before the appellate court, what are the appellate court can do? That provisions is given in 107 of the CPC, which says that the appellate court has got various powers. Number one, either to remand a case, or to frame fresh issues, or refer the very same issues for trial again, or allow the parties to reapprise the evidence when a finding of the fact is challenged before it, to summon witnesses. Suppose the appellate court realizes that I can myself dispose of because it's a very short point, I need to work out on that. I can myself allow the summon the witnesses to give me those disclosure or the establish those cases, establish that matter which is completely under controversy. That also can be done. Or can reverse the inference of lower court if it is the court finds that they are not justified, and they can do that. And if the court, appellate court, comes to conclusion that the evidence was not appreciated properly, then court can, depending on whatever is the matter on record before the court, the pleading, the evidence, they can apply their own mind and come to the finding. Now, section 108 says that the provision of section 8 relating to appeal from original decree will also apply to the second appeal and also to any other appeal from order. So that's the chapter as regards the appeal from order is concerned and decree is concerned. Second appeal, first appeal. Now that one chapter is over. Now second aspect. The matter has gone to appeal, second appeal. Now after second appeal, there is no third appeal. So your rights are foreclosed. Where do you go? That, therefore, there's a provision under the, you go straight away to the Supreme Court. Now those provisions are contained in various provisions. They are 45, order 45, section 1092, section 112, article 132, article 133, and article 136. These are the provisions which govern for permitting a party who's agreed either under the second appeal or where no appeal lies and the finding has taken place in him, against him, to go to court. Now, what are the criteria? Number one, as we all know that the Supreme Court is today the highest and final jurisdiction body, and they can entertain the cases or the appeal or the cases which are arising out of only High Court. Number one. Secondly, provided the High Court grants a special leave to prefer an appeal to go to Supreme Court. So such appeal can be filed by petition with the court which passed the decree, and such kind of application has to be disposed of within 60 days by the very same High Court which has passed the decree, and the court has to grant a certificate, issue a certificate of fitness. That is called certificate of fitness. There's a provision in the High Court which is there, the format is provided. That certificate also should, what should the memo of appeal should say? Normally all the memorandum of appeal should have the ground of appeal, number one. Then in present case of appeal before the Supreme Court, in addition to the grounds of appeal, depending on the rights or the whatever the entitlement or the permissible pleas that you can take under the various sections of the provisions, you have to take those. And in addition to those grounds, we also have to take the ground that you have to make an application that please issue a certificate that this involves substantial question of law which needs to be decided by the court. And then once the memo of appeal has been filed in the relevant High Court, in that case, along with the plea for issuing a certificate, the opposite party will be given an opportunity and he will give his objection. Depending on the merit and demerit of the objection of the respondent, the court will frame the question of law and issue a certificate. On that basis, an appeal can be preferred in the Supreme Court. Now, apart from that, there is an article 132 also provides for independent of the Constitution of India, apart from the Civil Procedure Code, to prefer an appeal to Supreme Court from any judgment, decree or final order of a High Court, whether civil, criminal or proceedings in the High Court. Now this is the second certificate. If the High Court certifies under Article 134A that case involves a substantial question of law. So under Order 45 as well as under the Article 132, the criteria is very simple. Under Order 45 read with 107 to 109, 109 to 112, the criteria is identical except that in the Order 45, civil matters based on the certificate that it involves a substantial question of law, the appeal can be made before Supreme Court, whereas under Article 132, it is a very vast powers given to the court. That is, even if it is judgment, decree or final order, whatever it may be, if the High Court certifies under Article 134A that this involves a substantial question of law, so whether it is a judgment, order, decree, everything can be brought before the Supreme Court. Now, there are certain rules which are given under the Supreme Court. If the matter goes to the Supreme Court, Rule 910 that can be referred, that 910 to 923. All those provisions can be looked into. And then apart from that, there is a section 133 of the Constitution of India and section 109 of the CPC, which provides for civil appeals, which also says that appeal shall lie to Supreme Court from a judgment, decree or final order. It involves a substantial question of law of general importance, and that such questions, and the High Court certifies that the Supreme Court should determine such question of law. Now, this is apart from that 132, Article 132, Order 45. There's a provision under Article 136. This is called special leave petition. These are very overriding powers which were given to the Supreme Court, which can entertain any appeal before it on any matter. So that is called SLP, which is very popularly known as. That also we need to take into consideration. I hope as regards the appeal review reference. Now there are also other provisions for appeal under various statutes. I have already told. For example, in the case of Commercial Courts Act, is a special statute under this within the CPC. Section 13 of the CPC Commercial Courts Act provides for an appeal. Likewise, under regular RERA, Real Estate Regulation Authority, there's a provision that after the order of if anybody is agreed by the order of appellate court, one can file an appeal under the 96, I think, section 96 of the RERA to the Honorable High Court. So those items can be definitely looked into. So that completes the discussion on the appeal. Now coming to reference. In the case of reference, there's a different setup. Here, the parties do not themselves go to file a reference to the High Court. Only High Court takes up the reference. Lower court takes up the matter and then frame certain questions regarding constitutional validity of the acts. For example, during the course of the hearing of the matter, the court feels that there's a doubt with regard to the implementability, or there's a problem in the act, what is to be done, or any ordinance or rule or regulations. In that case, the civil court is empowered to frame a point of reference, and they can refer to the High Court for its decision. And based on the decision of the High Court on those reference, the High Court will decide the question and relegate back to the civil court, and ultimately the matter will be decided in consonance with the matter decided by the High Court. And one of the example was that is very popular, also very well known, that in one of the matter where the section 69A of the Indian Partnership Act was valid or not, or in fact it was on reference by the City Civil Court before the High Court was ordered to be struck down. Now, so therefore, what is important that following conditions should be laid down. The criteria has to be fulfilled. Number one, there must be a pending suit or appeal in which the decree is not subject to appeal, or pending proceeding in execution of decree. Second, question of law or usage must arise during the course of such suit. This is for reference. These are grounds. Appeal or the court trying the suit or appeal or executing court must entertain a reasonable doubt on such question. So these are the three grounds based on which the lower court can put up the matter before the High Court for deciding the question. Second, the power to refer a question to High Court lies only with the courts. Therefore, this is not a remedy which is given to parties to the dispute. It is a power given to the court, and it is only to the court, and there's no such power conferred upon the tribunal. That we need to take into consideration. Now, so therefore, to some extent, the power of reference is slightly not available to the individual litigant. Now coming to the review. Review in the sense that the court which has passed the decree or the order, and the remedy lies, and if there is no appeal provisions, in that case, prior to preferring the appeal, one can exercise the right of review. What does the review means? Review means if a judge has passed certain orders, you make an application before the very same judge for a review. The court will decide. The provisions are contained in section 114 of the CPC, and it says the legal procedure is that once a judgment is signed and pronounced by the court, the court becomes functus officio, and he ceases to have a control over the matter. That means if the judge has passed the decree, that matter is over. He can't go back to the same matter and start re-agitating the same issue, or maybe try to look into the matter again. He can't modify it. He can do nothing. So therefore, that is a general principle. But the power of review under section 114 is an exception to that rule. Now, object has been laid down in the case law of Nagaraj versus State of Karnataka, 1993, supplement to SCR 1. The court has said that any human being can make a mistake or error, and so do the judges. So the procedure of review has been embedded in the legal system to correct the mistakes and prevent any miscarriage of justice. That's what the court has said. And the very same principle also applies in deciding the appeal, deciding the decree, passing the order. So therefore, the circumstances when a review petition is maintainable when, number one, under the following circumstances: when no appeal lies in the case; second, when appeal lies in a case but no appeal has been preferred; and second thing is, what are the grounds that we can do. The first ground is that there's some discovery of new and important matter of evidence that has been discovered, that also can be brought before the very court for review, or there was certain mistake or errors which occurred on the face of the record. This is also on the face of record, in that case that also taken, or any other sufficient reason. So that's the power of review. There are no in case of Shivdev Singh versus State of Punjab, the court has held that if there is a miscarriage of justice, in that case also the court can look into the review provisions. Now coming to revision, which is the last item. Revision means to revise or look again, or look repeatedly, or to go through the matter carefully and correct wherever necessary. These powers are conferred upon High Court under section 115 of the CPC. The important case laws and the leading case laws, although it is of 1964, but continues the same provision. The position remains the same. AIR 1964, Supreme Court 497. The court has held that the courts are empowered to keep an eye on the proceedings of the subordinate courts. So basically, it's a power of superintendence over the lower court. This is in addition to what is given under Article 227 of the Constitution of India. So what are the important conditions? Number one, the case must be decided. The revisional jurisdiction is exercised where no appeal lies. Then subordinate court has decided such a case by exercising jurisdiction which is not vested or to that court by law, or it has failed to exercise the vested jurisdiction, or illegal exercise of the vested power, or with immaterial irregularity. These are the grounds on the basis of which the revision can be filed. Now, Article 131 of the Limitation Act provides for 90 days, and therefore the such kind of provisions can be considered. Now, I think I have completed the entire concept on appeal, reference, review, revision, and order on withdrawal, the question of compromise. Now, coming to certain guidelines. First thing, let us understand, when we are writing exams, this is not a exam which we are writing for getting LLB degree, because in LLB degree the criteria is only to just answer in a nutshell, or maybe give us some kind of broad hypothesis, broad understanding about the concept of the questions that is asked. In the case of the solicitor exams, those people who appear for the solicitors, it is something like they expect you to write the exams as an expert, as if you are giving an opinion to your client. That kind of test has to be applied while writing exams, either not only in the CPC papers, in all papers. So you must exuberate enough confidence as far as, and it should be it should reflect in your paper. That is more important. Wherever any concept is to be supported by any decided case laws, cite those judgments. Two, and thirdly, that depending on and also one should not show any overconfidence. That also may go against. In that case, one has to be very calculated, very judicious in writing exams, exactly understanding the concept, and by looking, for example, it should be as if the person who's checking a paper is the person who is your client. He has come with those questions by way of examination paper, and you have answered to his queries, and that queries, whatever you have answered, the client has acted upon that. He has gone to, and that has been tested, tried, and has been upheld to be valid right up to the Supreme Court. That kind of answer should be written, and clarity has to be there. That is the criteria that one has to look into. Now I'll just share those case laws in the group. Just give me a minute. Just give me a minute. And I thank all of you for joining, and such a wonderful to enable me to give a detail about the various concept of law. I'll just share the video. I'm sharing two files. One is a file which is a I've come across during my research, which talks about various judgments which has been summary of various judgments passed in various matters, especially in the context of CPC, that I'll be sharing, that I'm sharing right now. Second is the judgment which I have taken into consideration while discussing the matter. That also I'll share just now. So I have shared both the two drafts. Now what is important is that CPC comprises of the sections. CPC comprises of High Court rules. There are certain, if it is not in the content in the High Court, there are certain rules and forms which are also there in the High Court rules itself. So basically one has to take into consideration while drafting the notes. Whenever any particular section is cited, one has to give the complete picture. That is important. For example, in the case of amendment of pleadings, Order 6, Rule 17 is not the sole section or the same, not the sole order which talks about it. There is Order 6, Rule 16 also. There are amendment in amendment of orders, arithmetic, amendment of any correction or the errors in the orders. That also comes under the amendment. That is under section from 136 onwards. I think I'll check up that. So therefore, any particular concept, any question that is given on amendment. So therefore, all these sections which are given, or which are sections and orders which cover that concept, has to be consolidated. Otherwise, it will be only showing that you have a knowledge about only one particular section, and other things you have totally not taken into consideration. That may also curtail your assessment. And wherever High Court rule is concerned, definitely that you have to cite. And with that, I think I'll conclude my present discussion. And I hope that you have it has been informative. And thank you all of you, and wish you all the best. Thank you, sir. Thank you, Jani sir, and also Nilesh bhai for giving an opportunity to present.
So thank you all. Mr. Verma has given you the hints also, and he has also in detail explained you everything. Thank you, Mr. Verma, for spending so much time for the students here, article clerks. And now, as I had mentioned, the next lecture is on Wednesday, 4:30 by Mr. Vyom Shah, who will be covering Commercial Courts Act, the letters patent, and the Constitution, certain articles that are there, and also the specific relief act. So do join in on Wednesday. Thank you. Thank you, Mr. Verma.
Thank you so much. Thank you, sir.